Thank you, Mr. President. Mr. President, members of the Court, it is an honour to appear before you and to do so on behalf of Turkey. Mr. President, in its decision in Zenides Orestes, the Court asked Turkey to establish a domestic remedy for all property claims in northern Cyprus. It identified 5 changes that were needed in existing law. First, to introduce the possibility of restitution of immovable property. Second, the possibility of redress for loss of movable property. Third, an international element in the composition of the Immovable Property Commission. I shall refer to the Commission in future as the IPC. Fourth, damages for non-pecuniary loss. And fifth, that the law should apply retrospectively. Turkey complied fully with the Court's request by adopting Law Number 67 of 2005. The Court then noted in its December 2006 judgment that the new law in principle satisfied all these requirements. At the same time, however, the Greek Cypriot authorities have consistently sought to disrupt the operation of this remedy, which they persist in describing as illegal. A central fact in the 8 applications before you today is that not one of the applicants has taken any step to exhaust the available domestic remedies. They have all declined to do so, notwithstanding the findings of this Court in the Zenides Orestes pilot proceedings. As you will recall, the judgment on the merits in that case, in that judgment, the Court suspended consideration of all applications deriving from the same general cause, including the 8 before you today. Then, in its just satisfaction judgment, the Court held, and I quote, that the new compensation and restitution mechanism in principle has taken care of the requirements of the decision of the Court on admissibility and the judgment on the merits. I need hardly stress, Mr. President, that the present proceedings are important, not just for the 8 applications, but for all applications deriving from the same general cause. There are, we understand, about 1,475 pending applications, and there could well be more to come in the future. Many involve more than one applicant. In an attempt to justify their passive stance, the applicants put forward 3 basic arguments. First, they say that the remedy in question was introduced after their applications were lodged. Second, that the remedy is, as they put it, illegal. And third, that the remedy is inadequate and ineffective. It is our submission that the remedy meets all the concerns of the Court in Zenides Orestes, and it is adequate and effective. The applicants have thus failed to exhaust domestic remedies as required by Article 35 of the Convention. Mr. President, members of the Court, at the outset I should like to make one general point. This hearing takes place in the context of your decisions and judgments in earlier cases. In the most recent Cyprus-Turkey interstate case, in Zenides Orestes, and in other cases concerning property in northern Cyprus. The case law of the Court has already decided many of the issues. Whether we agree with them or not, for the purposes of the present hearing, Turkey does not seek to challenge previous findings of the Court in related cases. Mr. President, the applicant's first argument is that they should not be required to exhaust the domestic remedy because it was not introduced in a timely fashion. They say that, whatever may be the position of others, given the time that has passed since they lodged their applications, they at any rate should not be required to exhaust the remedy. With respect, this line of argument is wholly unconvincing. It is inconsistent with the Court's decision to suspend consideration of all applications deriving from the same general cause. It would result in unjustified discrimination between applicants based on matters such as age and time of lodging of the application. It ignores the principle of subsidiarity that underlies the convention system, and it amounts to a rejection of the whole purpose of the pilot procedure. Mr. President, I now turn to the second main argument of our opponents, which I can deal with equally briefly. The third-party intervener, in particular, invites the Court to revisit its earlier findings on the lawfulness of remedies introduced by Turkey in northern Cyprus. There is nothing new in these arguments. They have all been rejected by a long line of established case law and practice. Case law and practice of the Commission, of the Court, of the Committee of Ministers. The case law stretches back at least to the most recent interstate case in 2001. It continues to the present with cases this year such as Protopapa and Alexandrou. In Alexandrou, the Court said that it was satisfied that the settlement is based on respect for human rights as defined in the Convention. That settlement was, of course, reached on the basis of the 2005 law. As I have said, the IPC was set up in response to the Court's judgment in Zinidis Orestes. Our opponent's argument is tantamount to inviting the Court to find that the Court asked Turkey to introduce an unlawful remedy. That makes no sense. There is, Mr. President, in our submission, no reason for the Court to reconsider the lawfulness of the remedy. I now turn to the third issue raised by the applicants, the adequacy and effectiveness of the remedy under the 2005 law. We described this in detail in our memorial. We have recently informed the Court of 3 developments in the 6 or so weeks since the memorial was submitted. First, the deadline for applications to the IPC has once again been extended by a further 2 years. It now expires on 21 December 2011. Second, a budget law has been enacted providing for very substantial resources to finance the activities of the IPC, resources that are earmarked exclusively for the IPC. Third, 12 new applications have been made to the IPC in this short period of 6 weeks, making a total of 433 in all. And 9 new friendly settlements have been reached. This shows, Mr. President, that the work of the IPC is active and ongoing. The figures alone show that the domestic remedy is effective. And this, despite all the harassment and intimidation by the intervener in its efforts to make the remedy fail. The Court is well aware of the pressures that the applicants are under from the Greek Cypriot authorities. For example, in its letter convening the hearing in the Zinidis Orestes pilot case, the Court specifically asked whether the applicants were being discouraged by the authorities from having recourse to the IPC, and if so, in what way.